you said minority rights are now part of the basic structure of the Constitution and that the Supreme Court itself has recognized that they are part of the basic structure. So they are inviolable. You cannot change them because they are part of the basic structure.
This is 73 Kesavananda Bharati itself, they said that it is a part of the basic structure. And if you go to St. Xavier's judgment, which is 74, they have said that no tampering with these rights will be permissible so long this constitution survives.
The line slightly broke. Which year's Supreme Court judgment did you mention? Was it 1970?
It is 1974 St. Xavier's judgment, where Supreme Court said that no tampering with these rights would be permissible so long as constitution survives. And minority rights are the part of a basic structure was said in the Kesavananda Bharati case itself, in which basic structure doctrine was propounded in 1973.
Hello and welcome to a special interview for The Wire. On the day the Constitution marks the 75th anniversary of its adoption, we examine what in recent years has become one of its most controversial aspects, minority rights. Why did Dr. Ambedkar and the Constitution makers feel such rights were required? How have the courts interpreted them over the last 7 decades? Why does Hindutva consider this unwarranted appeasement? And what are minority institutions believed to be when people claim they are less well governed than others? Those are some of the issues I shall discuss with the Vice-Chancellor of the Chanakya National Law University and a Professor of Law at Aligarh Muslim University, Faizan Mustafa. Professor Mustafa, the recent Aligarh Muslim University judgment has once again created both interest in and controversy around the issue of minority rights. So let me start with a couple of general questions. First of all, am I right in saying the term minority covers both religious minorities as well as linguistic minorities? So we're not just talking about Muslims, Christians, Sikhs, Jains, Buddhists, and Parsis. We're also talking about Hindus in Kashmir, Punjab, and parts of the Northeast, as well as linguistic minorities such as Tamil speakers in UP or Urdu speakers in Karnataka and Telangana. Is that right?
Yeah, it is right because Article 30 uses two words. Minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In fact, we have more linguistic minority institutions than religious minority institutions because the diversity of the country is basically reflected in our linguistic diversity. So the framers of the Constitution decided that let the minorities be defined not at the level of the center. There are consistent line of judgments of the Supreme Court which said that minorities will be defined at the level of state because states were carved out on the basis of language, as you know. Therefore, in each state, who is a minority would differ. So maybe a Tamil Brahmin in UP would be a minority, or Hindus in Punjab or in northeastern state or in Kashmir or Lakshadweep will be a minority, and their rights are same. Whatever rights are available to Christians and Muslims under Article 30, same rights are available to Hindus who in some states and union territories are religious minorities, but they can be linguistic minorities in all other states and union territories. Even in Delhi, you have number of Sindhi Hindu minority institutions.
You make a very important point there. Most people believe that minority institutions are minority institutions on the basis of religious minorities. You're actually saying that the truth is there are more linguistic based minority institutions than there are religious based ones. That's a very important point that most people haven't appreciated.
And that's why, they think that Article 30 is some kind of appeasement. It is not an appeasement, it is preservation of diversity. How do we preserve our diversity? That is what is the object of Article 30 is all about.
Now tell me, why did our constitution makers, way back in 47, 48, and 49, believe that we needed minority rights? Why did they not conclude that the right to equality and the right not to be discriminated against, which are fundamental and key parts of our constitution, are sufficient to safeguard the interests of minorities? Why do we, in addition, need specific minority rights?
You see, Karan, in 19th century itself, if you go to Austrian Constitution of 1967 and you go to Hungary's Constitution of 68 or the Swiss Constitution of 1874, these constitutions had guaranteed the minority rights. Then, after the World War One, number of peace treaties were signed to protect the minority rights. Now, somehow, what happened after the First World War, when you got into this Italian totalitarianism and you got Hitler in Germany, it was somehow considered that the minority rights have not really helped the Jews. And therefore, in the Universal Declaration of Human Rights, they shifted focus from the minority rights, which is a group right, to the individual rights. But subsequently, they realized that one's right to culture cannot be realized if you do not just say that one has a right to community, but also his community's right to exist in a viable form is also protected. Say, I cannot do my Garba or my Matam in Muharram or Rath Yatra without a group. So I need a conducive environment for the realization of those rights. So basically, group rights are important. Right to equality is an individual's right. So as an individual, I may never be discriminated. But the group to which I belong, if that group is subjected to ridicule or discrimination or is not allowed to exist, it is basically the violation of my right to dignity. And that is why the framers of Indian Constitution, particularly in the post-partition era, they wanted to satisfy the minorities' right to culture. And since they were so framing their rights, see, if you look at Article 29, it says any section of Indian citizens having the distinctive language, script, and culture of its own shall have the right to conserve the same. So this is the right of every citizen. And then in 30, they said religious minorities as well as linguistic minorities will have right to establish their institutions. So basically, Article 30 is another facet of right to equality. You know, you have two kinds of equality. Formal equality is in Article 14. We say that everyone is equal. But then substantive equality requires that you go a step ahead to create equal opportunities. And that's why minority rights were given so that minorities also get the same rights which are available to the majority.
You're making two very important points, and I'm underlining them for the audience. First of all, you point out that whilst the right to equality or the right not to be discriminated against are individual rights, minority rights are group rights, and that group right exists to enshrine the fact that groups, as you put it, have a right to exist in a viable form as a viable entity. And the second important point you make is that the concept of minority rights actually has a well-based international history. It goes back to the Swiss Constitution of 1874, and it was again implemented in the Austrian and Hungarian constitutions of 66, 67, and 68. So this is not just a concept that is well established in international constitutional law, but it is also distinct from individual rights. It is a group right.
Yeah, that's right.
Now, over the last 75 years that the Constitution has been in existence, how have minority rights been interpreted by India's courts? Is there a clear line of logic and interpretation that runs through it, or has it differed from case to case?
Very interesting. As you know, that in a communist system, state is everywhere. Therefore, the first case started from Kerala, where the government tried to control the minority institutions. And the matter was referred to the Supreme Court, and Supreme Court gave an advisory opinion, which is widely respected and has been consistently followed in all judgments of the courts, including in the recent one in Aligarh Muslim University. So our Supreme Court has very, very liberally interpreted minority rights. They have said it is the part of the basic structure. and therefore you cannot remove them. There has been a time when there was a committee headed by K.R. Malkani, which has suggested that Article 30 should be deleted from the Constitution. Then the words used in Article 30 were liberally interpreted. For instance, if you go to the European examples which I gave, that they are basically talking of right of minorities to set up schools, and largely the unaided schools. But in India, our constitution framers, in the constitution itself, they have written that the government, in granting aid to an educational institution, shall not discriminate against that institution if it is under the management of a minority. What is the meaning of word educational institution? Our courts have not confined it to just schools. They have said it includes universities, it includes education at every level. What is the meaning of word choice? Supreme Court has said that the dominant word in Article 30 is choice, and it is within the power of the minority to expand their choice as much as they want. And now the Supreme Court has also said that even an institution of national importance, which is mentioned in the Constitution as an institution of national importance, can also be a minority institution. After all, minorities are also part of the nation. And if their institutions are great, they may be on the one hand institution of national importance, and on the other hand, they can be a minority institution. Then our courts have also said that government can bring regulations, but no regulation can destroy the minority character. It cannot be annihilative of the minority character. So our Supreme Court has been very, very liberal in interpreting Article 30. The only aberration was the Aligarh Muslim University's case in 1967, which the Supreme Court has now fortunately overruled.
But again, Professor Mustafa, you began with a very important point. You said minority rights are now part of the basic structure of the Constitution, and that the Supreme Court itself has recognized that they are part of the basic structure. So they are inviolable. You cannot change them because they are part of the basic structure.
This is 73. Kesavananda Bharati itself, they said that it is a part of the basic structure. And if you go to St. Xavier's judgment, which is 74, they have said that no tampering with these rights will be permissible so long this constitution survives.
The line slightly broke. Which year's Supreme Court judgment did you mention? Was it 1970?
It is 1974 St. Xavier's judgment, where Supreme Court said that no tampering with these rights would be permissible so long as Constitution survives. And minority rights are the part of a basic structure was said in the Kesavananda Bharati case itself, in which basic structure doctrine was propounded in 1973.
This again is very important. In 1974, in the Xavier's case, the Supreme Court said explicitly that no tampering with minority rights is permissible as long as the Constitution survives.
That's right.
Now, in contrast to what you've been saying to me, the proponents of Hindutva consider minority rights to be a form of appeasement. Worse, they believe that they are unwarranted favoritism and discrimination. How do you respond to the Hindutva position?
This is entirely wrong and baseless. It shows their ignorance of constitutional provisions and the narrow mindedness. The mere fact that the minorities are not defined just in terms of religion, but also in terms of linguistic minorities. There is a DAV College Jalandhar judgment where they tried to impose Gurmukhi as a medium of instruction and examination on all institutions in Punjab. And Supreme Court said, no, you cannot impose Gurmukhi on the Arya Samaj institution. So Hindus were recognized as a minority. In fact, there has been a time when I had written for Outlook that even the Banaras Hindu University was also established as a minority university, because minorities are defined either on the basis of numerical inferiority, that you are less than 50%, or on the basis of powerlessness. So during the British regime, even though Hindus were in a majority, but they were powerless in the power structure of the state, because it was entirely, power was with the British government. And that's why if you look at the Banaras Hindu University Act, it is entirely different from Calcutta and Bombay and Madras or the Patna Acts. So it is wrong. The other thing is, in minority institutions, 50% non-minorities are studying. And therefore, minority institutions are basically doing a great national service. Karan, you have to understand that the right to education is available to every citizen under Article 21A between ages 6 to 14. So basically, it is the responsibility of the state to educate everyone. Now, state does not have resources. If you look at the government institutions, many government colleges have just one teacher. And if you look at the ACER reports, the quality of education in many government schools is not great. So minorities are pooling their resources, investing their time, establishing their institutions. And in those institutions, they are also educating non-minorities. Therefore, to say that this is something of an appeasement, I don't think that this is a fair charge.
You also pointed out that, and BHU is the example of that, minorities can be established not just on a numerical basis of being less than the majority, but also on the basis of powerlessness,
That's
whereby a majority can claim that, as it did in the days of the British Raj, they were powerless. Does that concept of minority still continue today, or has that ended with independence?
No, if you look at, let us look at the apartheid South Africa. I'm talking of international law. So the blacks were more in number, but they were powerless and they were given a protection of minority rights. In India, we did not adopt the powerlessness test. We adopted the numerical inferiority test. And our Supreme Court has been continuously saying that anyone in a state who is less than 50% would be a minority. I remember, Karan, that there is a judgment from Allahabad High Court in which they said Muslims are not a minority. Many people today say that since Muslims are too many, therefore they are not a minority. Even in the Aligarh Muslim University appeal, Justice A. N. Ray, who was a Chief Justice of Allahabad High Court in 2005, during the hearing, he was saying unless there is a threat of extinction to a community, you are not a minority. And Dr. Rajiv Dhawan was arguing, and he had to say that you are a high court, you are bound by the judicial discipline of the Supreme Court. So if somebody is even 49.9%, as law stands today, he is a numerical minority. So, but if you look at TMA Pi judgment, Justice Qadri in his concurring judgment has said that powerlessness of a group can also be taken into account in determining the minority status of a group.
So, to the extent Justice Qadri's judgment actually lays down some sort of precedent, powerlessness is still a criteria for determining minority status, according to Justice Qadri.
He says that this is also one aspect because he is talking of international norms in determining how do you decide minority. But you see, there has been some regressive judgments. I recall the Bal Patil judgment, where Supreme Court refused to recognize Jains as a minority. Now, our right to freedom of religion does not say that we would believe only in the existing religion. Tomorrow, a new religion may be created. People may follow that religion and may become a religious minority. But Supreme Court said, let us not add to the list of the minorities. We should not look at the whole question of a minority as something which is wrong or which is bad. Minority rights is not something bad. It is very much the part of international human rights law. We have individual rights, which are called civil and political rights. We have group rights, which are called socio-economic and cultural rights. And after 1993, United Nations Human Rights Convention has decided that these rights are universal and they are indivisible and inalienable.
Now, on Saturday, the Prime Minister said, and I'm quoting him, the Constitution does not have any place for the Waqf Act. On Sunday, Piyush Goyal went one step further and directly called the Waqf Act unconstitutional. He called it appeasement. How do you counter that viewpoint?
Karan, I am a student of constitutional law. In constitution, there are two kinds of things. One, you have to look at the right of people. Fundamental rights are rights of people. Now, if you look at Article 26 of Indian Constitution, it is very clearly saying every religious denomination or any section thereof shall have the right to establish and manage charitable and religious institutions. So forget about just the right of people. It is a right which Constitution gives to every religious group, to every religion, every religious denomination. So this is the right of people very much there as part of fundamental right. Then you come to the power of governments. We have a concurrent list under which both center as well as state governments can pass laws. Now, entries give you the field of activity. Entry number 28 is very clear. It is talking about charities. It is talking about religious as well as charitable institutions. And that is why not only the center has been continuously passing Waqf laws, the latest bill which is pending with the parliament, we have proposed 44 amendments in the 1995 law which was passed by the parliament. In number of states, you are having Hindu religious and charitable endowment acts. You have a Sikh Gurdwara Prabandhak Committee Act. Therefore, to say that the constitution does not know of religious and charitable endowments means that we have not looked at the constitution.
Well, let's hope the Prime Minister and Piyush Goyal are listening to you very carefully. Now, let me at this point come to the recent Aligarh Muslim University judgment passed by the Supreme Court. That judgment laid down the criteria by which minority institutions should be determined. What is that criteria, and do you believe it is the right one?
In TMA Pi, which was a 11 judge bench judgment of 2002, there was a question number 3A, where this question was framed that what is the indicia to determine whether an institution is a minority institution or not. But there, the 11 judge bench did not answer this question. Then in 2019, a 3 judge bench referred this matter as well as the Aligarh Muslim University matter because the 1967 judgment of Aligarh Muslim University was criticized by a number of scholars, including H.M. Sirvai, who said that this is productive of great public mischief and must be overruled. So now Supreme Court, for the first time, authoritatively has laid down the yardsticks on which you will test whether an institution is a minority institution or not. Generally, wherever somebody asserted that we are a minority institution, the court did not go into the minority question. The only aberration of doing a microscopic scrutiny, whether an institution is a minority or not, was Aligarh Muslim University in 67, in 2005 in Allahabad, and in 2024 in the Supreme Court, and will again be done when the 3 judge bench hears this matter. But what the Supreme Court has now laid down, and a number of points, there is a unanimity. It is 7-0 when it comes whether the yardstick should be broad, flexible, and should not be rigid. So now Supreme Court is saying that you should not just look at the establishment when the institution came into being through a legal device which was necessary. For instance, in case of Aligarh Muslim University, to become a corporate entity, you needed a law incorporating the university. Now that law came in 1920. What Supreme Court is saying that you have to look at the foundation moment of that institution. You have to go to the genesis of that institution. Who conceived that idea? So that person who conceived the idea must belong to a minority. And how he raised funds, how he went to the government, what kind of support government gave, you have to look at the whole implementation of that idea. So Supreme Court has very clearly now laid down the yardsticks on the basis of which one can determine the minority status of an institution. I think these are absolutely reasonable based on all the earlier judgments of the Supreme Court. Supreme Court has been consistently saying that fundamental rights are to be read even to pre-constitution institution. Therefore, St. Stephen's, which is a 19th century institution, or Aligarh Muslim University, which was also established as MAO College in 1877, are fully entitled to Article 30 protection. Because one of the arguments from the other side was that you cannot extend the protection of minority rights to pre-constitution institution. Supreme Court has very clearly now said that this protection would be available to pre-constitution institution. So ideation and then implementation, raising of funds, and the primary object of the institution should be the education of that particular religious or linguistic minority. These are the yardsticks on the basis of which today you have to decide whether an institution is a minority institution or not. By the way, we now have a National Minority Education Institutions Commission. There is another law which now, and a commission is there, which now determines the minority status of minority institutions. And on their website, you can see how many linguistic minority institutions are also there.
Now, whilst overturning the 1967 judgment that AMU is not a minority institution, the Supreme Court has still left it to a future bench, the three-judge bench that you mentioned a moment ago, to determine whether it fits into the new criteria laid down. Many people believe that when that subsequent bench decides, AMU will be considered a minority institution. Do you agree with that view, or do you have reasons to be doubtful?
The dissenting judge, Justice Dipankar Datta, has written very clearly that history will be created and it is a matter of time when Aligarh Muslim University would be declared as a minority institution. So, by and large, since the law has been laid down by a larger bench, a three-judge bench would be bound by that law. In all probability, Aligarh Muslim University, if it argues its case well, if it puts up good arguments and gives solid evidence on the basis of yardsticks which have been determined by the majority in this case, uh, ideally they should win. But in law, since I am a student of law, I know that you can always have a different kind of interpretation in law. So it is not right to predict what would be the judgment of a three-judge bench. We should keep our fingers crossed and let us hope for the best.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.
Let me, before I end, Professor Mustafa, ask you a few more questions about the nature and character of minority institutions, because they are at the heart of the controversy that is at the moment spreading and gaining a lot of momentum. What sort of power does the government have vis-a-vis minority educational institutions? And secondly, which are the areas where the institutions are free to decide for themselves?
This has also been the heart, as you rightly said, of minority debate. To believe that a minority institution becomes absolutely free from government control is not right. Government can still come up with all kinds of health, municipal regulations, educational standards, what would be the qualifications of teachers, qualifications of a vice-chancellor. No minority institution can say that I would appoint assistant professors who have not passed the UGC exam of JRF and NET. No minority institution can say that I would appoint people as professors who do not have 10 publications, and have PhD. So government can order audit. Government regulations can be there on everything, just like in any other institution. The only thing is that Supreme Court has come up with a dual test. How do you test a governmental regulation? And Supreme Court has said that the regulation must be regulative. It should not be annihilative of a minority character, and it should make that institution an effective vehicle of minority education. And minorities cannot know, minorities don't have a right to say that we will not be governed by government regulations. They are bound by government regulation. Just like any other institution, Minority institution would have right to admit students, right to fix their fee, right to choose their governing body, and right to discipline their employees. These rights are also available to non-minority institutions under Article 19, and they are additionally available to minority under Article 30. This is what it is.
Now, the recent Supreme Court judgment, and you mentioned this a moment ago in one of your answers, has ruled that minority institutions can be government aided. There's no reason to say that if a minority institution receives government aid, it ceases to be a minority institution. And on that basis, St. Stephen's, Aligarh Muslim University, or Jamia Millia Islamia, which are government aided, continue to be minority institutions. I take it your position is that this is the correct position laid down by the Supreme Court. You don't disagree here.
Consistent position from 1957 Kerala Education Bill to S.K. Patro to Father Cruz to Xavier's to St. Stephen's. Supreme Court has consistently said that receiving aid in no way dilutes the minority character. This is a myth that if you are an aided institution, then you cannot be a minority institution. One can be an aided institution as well as a minority institution. In fact, Supreme Court in Kerala Education Bill also said that institutions cannot survive without governmental aid. We need to understand that there are private unaided institutions as well in the country. They have maximum autonomy also. But the fee which they charge is beyond the means of large section of our population. So we need aided minority institutions where poorer sections of minorities, whether religious or linguistic minorities, can study there. No institution, even Delhi University, does not have a right to get aid from the government. Every year they will send their request to the government that we need 2,000 crore. Government will give them 1,300 crores like that. Similarly, Article 30 is explicit on this point. And TV anchors, simply don't read Article 30 Clause 2, that government, when it comes to the question of grant of aid, will not discriminate against a minority institution. So there can be a minority institution which is also aided, but if you are aided, then your autonomy gets reduced. You will have greater oversight of the government. For instance, now your accounts, if you are receiving central government funding, will be audited by CAG. Now, if you are a central university, the annual report of the university would be laid before the parliament every year. The Vice-Chancellor shall be appointed by the President of India in his capacity as the visitor of those universities. The only problem which I see with the latest judgment is that Supreme Court has been saying all through that this is what the administration means. A minority university, particularly, Karan, should not be asked to indulge in ghettoization. It is not a madrasa. Therefore, to say that a minority institution should largely have people or overwhelmingly have people in the administration of that community is a too heavy a condition, because a minority may not have neurosurgeons available in that community. So they need to take the help from the other community. The only thing is their student body, they should have about 50% students from that community, but in their teaching staff, they should be allowed to have people from other communities, because then only you can have high educational standards. CMS Vellore or St. Stephen's are able to maintain good standards because their teaching staff is not entirely consisting of members of the Christian community.
And one of the corollaries of what you've just said is that the view that minority institutions cannot be government aided, a view that is often propounded by TV anchors, as you pointed out, or often propounded by panelists from the right-wing spectrum of political opinion, that view is incorrect. A minority institution can be government aided, and the claim that because it's government aided, it ceases to be minority is wrong.
Absolutely wrong and unconstitutional. They have not even looked at Article 30 if they say so.
My last question. One argument that you often hear is leveled as a criticism against minority institutions. It's claimed that minority educational institutions, as a result of being minority administered, are also poorly administered. How true or false is that claim?
You see, minorities don't have right to maladminister, and non-minority institutions also don't have right to maladminister. Even religious institutions cannot have right to maladminister. Why have Waqf law? So that Waqf is better managed. Waqf board is not some private body of Muslims. It is a statutory body. It is a state within the meaning of Article 12. Similarly, in Tamil Nadu or Karnataka and number of other states, we have religious and charitable boards for Hindus. The whole idea is that there is a better management. Now, there can be a bad vice chancellor, there can be a bad principal of a school which is under a management of a minority, and therefore they may have a bad patch. But to say that all minority institutions are badly managed is wrong, because some of the minority institutions are leading institutions. Look at Jamia and Aligarh Muslim University. In all rankings, national and international rankings, you will always find them in top 10 or top 12 or top 15. Similarly, St. Stephen's will always be, at the top. Or CMS Vellore is highly ranked. You see, this whole argument of maladministration doesn't work. The current dispensation says nothing was done for 70 years and the country was very badly managed. They say that the 2004 to 2014 was a lost decade. Opposition, on the other hand, is saying that right now we are having misgovernance. So there is not much truth in it. The law is very clear that minorities have right to administer. They don't have right to maladminister. They should administer it effectively and efficiently, and minority institutions should be the best institutions. They should be islands of excellence. Then only that minority would really be able to do it. We must understand we are talking of secular education, liberal and modern education. We are not talking of religious education or madrasas or Vedic pathshalas under Article 30. It is in the national interest that if we want that minority to come in the national mainstream, that more and more government-aided minority institutions are established and minorities come in the national mainstream, their mental horizon should be broadened by receiving liberal, modern, progressive education.
Professor Mustafa, thank you very much for clarifying so simply but so effectively the whole concept of minority education and minority institutions. I'm deeply grateful for the time you've given me. Take care. Stay safe.
Thank you, Alice.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.